Today on Yeti at Large, a look at high-profile Arizona Supreme Court cases, including the pending case, Lake v. Hobbs. And welcome to Yeti at Large. This is a channel focused on making the most out of what you have, no matter where you're at. Thanks for tuning in and helping out. So this courthouse might look a little dated with its construction. But the interesting thing is there are facets of our law that hold water century after century, obviously going back to the Constitution and some of the original founding documents. A case precedent's being mentioned from the late 1890s, which was being tried in Arizona about the same time this courthouse was being put up. They're both still relevant today, and we're going to take a look at them. One of the challenges with high-profile court cases is the attention they draw and the circus atmosphere that can be rendered around them. This case here has drawn national and international attention. Some parts of it get very quiet because they're not spectacular to film or comment on. Those are the parts we're talking about today. So since we're talking about high-profile cases before the Arizona Supreme Court, we came back downtown to the complex. This is the backside of the Supreme Court building behind me. Now, out of respect for the decorum with the court rules, there's no filming inside unless you're specifically part of the media pool for a current event. That would be Rule 122 if I think off the top of my head. So here we are on the sidewalk across from the Arizona Supreme Court. Under the high-profile case section, see this screenshot. There are currently 5 cases filed since 2021 with Katie Hobbs listed as the defendant or an involved party. There's 3 others involving direct governmental issues at an executive level. There's even one still pending with our previous governor, Doug Ducey, and there's about to be one more, Lake versus Hobbs. In this case, it's going to look at election issues that were looked at the Superior Court and then at the Court of Appeals, and now there's a potential that the Arizona Supreme Court could pick that up. Let's go someplace a little more quiet and comfortable, and we'll look at some of the precedent, the cases that the Hobbs legal team has mentioned going back to the late 1800s, and some of the current cases in the Supreme Court high-profile case list. It's not uncommon for elected officials to be sued by various entities for several reasons. The number one tactic to avoid any severe penalties with those lawsuits is to A, have no unpublished agendas, B, live in the truth, and C, follow the law. Now the problem is the law sometimes isn't popular. Several groups want various public entities to not follow the law. They feel the law is unjust as it's written. But it's not up to a public official outside of the legislative branch in conjunction with their other legislators to change those laws. If you're in public service, it's your duty to follow that law as published, as printed, and as expected. Don't know who it was that said I'd rather be lucky than good, but while we were down here in the valley working on filming some of our high-profile Supreme Court cases, not the least of which being the Lake v. Hobbs campaign election case that is being petitioned before the Supreme Court as we speak. The Lake campaign is holding a prayer session at the Without Walls Church, which is out in East Mesa, Central Mesa area. Since we were down here, we decided to attend it. I've been to several of the campaign rallies covering those, but today's going to be a little bit different. We don't know if they're going to allow media, per se, into the sanctuary simply because as a prayer event, it's a little bit different than a typical rally. It's amazing the power of please and thank you. We've covered that in our communication principles, linked right here. So part of the blues of trying to YouTube is data management, data corruption, and data processing. And a large portion of the video that we shot was either damaged by too much wind noise or unrecoverable when I got to where I'm traveling to. So let's reshoot a little section of that. One of the things we were talking about were those high-profile cases and the precedents that were being mentioned. And the first one that I thought was interesting was Oaks v. Finley. That's Arizona, 1898. And the point was the court had said that they're not going to overturn the results of election refusing to disturb without proof of the most clear and conclusive character. Clear and convincing is a very common legal standard, and this is kind of where it had some of its roots. So the burden of proof is very high. It needs to be absolutely without any reasonable doubt that the results were skewed and needed to be changed. Leapfrog forward about 20 years to our first Arizona governor, W.P. Hunt, who served several terms, but he had lost one election, challenged it, and months later it was overturned, and he was instated in the governor's office. That was Hunt v. Campbell, 1917, and they applied that same clear and convincing standard. So, when you go to those burdens of proof, beyond a reasonable doubt or a preponderance of the evidence, criminal cases typically are much higher beyond a reasonable doubt, and a preponderance of the evidence is those civil level cases. Think of O.J. Simpson, where they acquitted him of the criminal charges, but he was found responsible for the civil charges. Switch that to the culpable mental states, and there's basically three we've talked about on this channel. There's recklessly, there's knowingly, and then there's intentionally. And the Superior Court required the plaintiff in Lake v. Hobbs to prove intentionally. Short of a confession, that can be very difficult. Knowingly is still a high standard, but much more achievable because you don't have to prove what the person's mental state was intentionally, whether or not they intended to not follow regulation, policy, law. The fact of the matter is, if you can prove they didn't, it's still knowingly because they have an obligation to perform the correct action as a public official. And that goes into those feasance categories we've talked about before: misfeasance, nonfeasance, or malfeasance. Nonfeasance is a duty to act and you don't. Misfeasance is doing the wrong thing, and malfeasance is doing intentional harm. So that's just a brief recap of that. One of the most interesting things that I've been thinking about while I was recording this video was the fact that I said earlier, you get in the public eye, you are going to be scrutinized, and you likely could be sued and challenged in court frequently. That kind of just comes with the turf. It doesn't necessarily mean that you're a bad actor. Matter of fact, I had the profound privilege of knowing the Phoenix police officer that actually arrested Ernesto Miranda. The Miranda warning, come out of Arizona. And speaking with him, I'm not going to give you his name here, you can do your own research. He had stated one time when I got early into law enforcement that, you're going to be sued, very likely. And if you're sued frequently and often, it means one of two things. And now this was just an opinion, but if you're sued frequently and often, it means you're either doing a lot of stuff really good or a lot of stuff really bad. He was convinced there was no middle ground in that. So when you see a politician's name on the Arizona Supreme Court roster with frequent lawsuits spread out over a span of time, and depending on your political preference and position, you could make the calculation that this person's really doing a lot of cutting edge work and getting under the status quo skin, trying to shake things up for the betterment of the constituency, or they're running afoul of common law and accepted practice, and people are trying to slow down the rate of change. Your call there. So I know I promised you a section on high-profile cases in the Arizona Supreme Court, but I thought it was in poor taste to post that while the Supreme Court was considering Lake v. Hobbs. And as I understand it, a ruling has just come down today, and I haven't read the decision or any of the briefings on it. But as I understand it, the Supreme Court is ordering the case back to the Superior Court for review of the voter signature verification issue. This is huge and monumental. It was also what I believe the topic that got my video pulled down off of YouTube, because candidate Lake showed those comparative ballots with what were reported to be signatures, never identified anybody, and there was a clear mismatch. So the interesting thing with that is one of those signatures was wrong, and for anybody in the AG's office or the Secretary of State's office to come forward and want to file a criminal complaint based on a violation of that ARS statute, they would have to acknowledge that they had endorsed a signature that potentially mismatched. Kind of a catch-22, if you will. So this is our retake on the high-profile cases in the Arizona Supreme Court. If you got nothing out of this, please understand there's a mountain of information available to John Q, taxpayer, and the public at general. 100% of the research that I do is driven through publicly available websites. I don't use any special credentials or logins that I have to discover what I learn. I'm just doing basic gumshoe work, burning the shoe leather, burning the midnight oil. Now, as time goes on, I'm going to re-affiliate myself and get affiliations that allow me to use some of those secret squirrel websites. But as you've noticed here, we're always very discreet and appropriate. We exercise exemplary tact. I don't want to cause injury to anybody. Don't want to throw anyone under the bus. Thank you so much for joining us here at Yeti at Large. The show goes on.